टाइम देना पड़ेगा. Yes. Yes.
With your lordship's permission. My lords were going through the judgment of Maratha reservation. And my lord, referring to various paragraphs, my lords had come up to para 467 at page 245.
Yes.
Your lordships have 245 minutes.
Judgments के लिए.
245 of the judgment in Maratha reservation.
Judgments में है ना.
2021 volume 8 SCC.
मैंने ऐसे खड़ा करो. हाँ ये.
Lord, this part of the discussion starts from para 460, Lords, which is where the Honorable Supreme Court in this judgment is taking into consideration the submission, Lord, whether the quantifiable data collected through a commission appointed, Lord, which in that case was the Gaikwad Commission, would fit into the description and fall within the exception of para 810 of the Indra Sahni's case, my lord, to qualify to be an exceptional circumstance to breach the rule of 50%. So, my lord, that discussion started from para 460. My lords had reached up to para 467. My lords. This is important, my lord, with reference to the arguments which are raised by the state in support of the legislation, that they intend to exactly do the same thing, my lord, that is to breach the rule of 50% laid down in Indra Sahni in para 809 and 810 with the use of quantifiable data which they say has been collected through, in the present case, the Mahajan Commission of 1983. So, my lord, para 467 quotes Nagaraj's judgment para 123 and the last 3-4 lines were relevant, my lords, in the quoted portion. It is made clear, your lordships have it, my lords?
Yes. Yes.
Yes, it is made clear that even if the state has compelling reasons, as stated above, the state will have to see that its reservation provision does not lead to excessiveness so as to breach the ceiling or limit of 50% or obliterate the creamy layer or extend reservation indefinitely. The Constitution Bench in para 123 held that the provisions of Article 16(4)(a) is an enabling provision and the state is not bound to make reservation for scheduled castes and scheduled tribes in matters of promotion, and however, if they wish to exercise their discretion and make such provision, the state has to collect quantifiable data showing backwardness of the class in inadequacy of representation. The above observation regarding quantifiable data was in relation to enabling power of the state to grant reservation in promotion to scheduled castes and scheduled tribes. It is further relevant to notice that in the last sentence of para 123 it is stated, it is made clear, then the same portion note that your lordships read above, the same part is repeated note. It is made clear that the 50% rule cannot be breached using quantifiable data. My lord, may turn over to page 470, para 470 minutes.
Please repeat the para.
My lords, para 470 on the next page, my lord, 246. The Constitution, the bench thus in the above case clearly laid down that even reservation for promotion ceiling of 50% cannot be breached. The Commission has completely erred in understanding the ratio of the judgment when the Commission took the view that on the quantifiable data, ceiling of 50% can be breached. There is no such ratio laid down by this court in M. Nagaraj. Hence, the very basis of the commission to proceed to examine the quantifiable data for exceeding the limit of 50% is unfounded. Para 326 of the report of the commission contains the heading quantifiable data. It is useful to extract para 236, which is, my lord, the entire para is extracted. My lord, may skip over the earlier part and come to where the percentages are noted, my lords. 35.7, my lords have it. Thereafter, my lord. Percentage of all the reserved backward classes to be 48.6%. In the state of Madhya Pradesh, my lord, it is 48.08%. The percentage of other classes or the population who have not disclosed their caste is shown to be 15.7%. From the survey of the report, though it relates to rural area, the percentage of the existing backward classes Maratha and Kunbi who claim to be backward comes to 48.6% plus 35.7% equivalent to 84.3% of the total population. There is no dispute that large population of Maratha and Kunbi castes as well as existing backward classes are inhabitants of the rural areas. 48.6% population of the existing reserved category includes scheduled castes, scheduled tribes, and all backward classes have been identified as socially and educationally backward. The Maratha caste has been identified socially and educationally and economically backward in the commission. So, as total 84.3% population can be said to be backward classes. Regarding the above noted quantifiable data, the commission has recorded its reason for reservation under Article 15.4 and 64 in para 259. We extract, my lord, this is important, blocks. To sum up, this commission has already found above on appreciation of evidence collected produced before it that 80 to 85% of the population in the state of Maharashtra is backward. According to the commission, to accommodate the 80 to 85% backward population, which is ceiling of 50%, will be injustice to them, and as such it would frustrate the very purpose of the reservation policy arising out of Article 15 and 16 of the Constitution. In the considered opinion of the commission, this is an extraordinary situation which has been mentioned in the second term of reference, and as required by Indira Sahni, 80 to 85% backward population adverted to above speaks about quantifiable contemporary data by Nagaraj. So this was the justification which was provided, my lords, that the quantifiable data is the extraordinary circumstance that the population is 80 to 85% of the OBC community, and therefore restricting reservation to 50% would not be proper, and hence treating the quantifiable data to be an extraordinary circumstance, it was recommended that higher reservation be provided. Then 473 minutes. It is clear that the entire basis of the commission to exceed 50% limit is that since the population of backward class is between 80 to 85%, reservation to them within the ceiling of 50% will be injustice to them. This is the conclusion, Lord, that the Honorable Supreme Court draws from the report. Then my lords may come to para 476 at the bottom. This court in several judgments has noticed that what can be the extraordinary situation as contemplated in para 810 in few other cases. We have referred to above three judge bench judgment in Union of India versus Rakesh Kumar, where the three judge bench held that exceptional case for 50% ceiling can be in regard to panchayats in scheduled areas. The above three judge bench has also been approved and reiterated by the Constitution bench of this court in K. Krishnamurthy. In the above cases, this court was examining the reservation in panchayats in the context of Part 9 of the Constitution. 50% ceiling principle was applied, but exception was noticed. In the above context, we also notice para 269 of the impugned judgment of the High Court, where the High Court has also come to the conclusion that the Maratha has made out a case of extraordinary situation within the meaning of para 810 of Indira Sahni case. The High Court in para 269 of the judgment made the following observations. My lord, this was the impugned order before the Honorable Supreme Court. We would curiously refer to the reports which would disclose that it is for the first time in the form of Gaikwad Commission, the quantifiable data has been collected, and in terms of Nagaraj, the quantifiable data inadequacy of representation are two key factors which would permit exceeding the reservation of 50% by the state. So this was the opinion of the High Court. The High Court has endorsed the opinion of the Commission that when the population of backward class is 85%, if they would get only 50%, it would not be valid. In para 275 of the impugned judgment, my lord may just skip over the top part. In the last 4 lines, my lord, after referring to the data and reservation percentages, it says, my lord, therefore, my lords have it. Last 4 lines, my lords. Therefore, in terms of the population,
Yes.
if we look at the figures, then the situation which emerges is that almost 85% of the population is of the backward classes. And to suggest that if 85% of the people are backward and they get only reservation of 50%, it would be travesty of justice. When we speak of equality, equality of status and opportunity, then whether this disparity would be referred to as achieving equality is the moot question. The situation of extraordinary circumstances, circumstances as set out, though by way of illustration in Indira Sahni, would thus get attracted, and the theme of the Indian Constitution to achieve equality can be attained. So this was the reasoning, my lord. Then my lord may have para 479. Again, in para 286 of the judgment, the High Court reiterated that extraordinary situations have been culled out by the report since backward class is 85%, Marathas being 30%. Treating the above to be extraordinary situation, the following observations have been made in para 286. Then the para 286 is reproduced. My lord may skip over that, my lords. That was to justify reservation to breach the limit, my lords. 280, my lords. From the above, it is clear that both the Commission and the High Court treated the extraordinary situations with regard to exceeding the 50% for granting separate reservation to Marathas. The fact that population of backward class is 85% and reservation limit is only 50%. The above extraordinary circumstances as opined by the Commission and approved by the High Court is not extraordinary situation as referred to in para 810 of Indira Sahni judgment. The Marathas are dominant and forward class and are in the mainstream of national life, which does not apply to us. The above situation is not an extraordinary situation contemplated by Indira Sahni judgment, and both the Commission and the High Court fell in error in accepting the above circumstances as extraordinary circumstances for exceeding the 50% limit. So it has been categorically held, my lords, whatever data can be collected with regard to backwardness or with regard to inadequacy of representation, Lord, what to speak of proportionality, but even if it is inadequacy of representation, then such quantifiable data, my lord, cannot fall into the parameters of being within the extraordinary situation, my lords, as specified in para 810 of Indira Sahni.
Yes.
My lords. My lord, this has been further emphasized in para 482, my lords.
Yes.
My lords. In view of the foregoing discussion, we are of the considered opinion that neither the Gaikwad Commission's report or report of the Gaikwad Commission nor the judgment of the High Court made out an extraordinary situation in the case of Marathas where ceiling of 50% can be exceeded. We have already noticed that the relevant discussion and conclusion of the Commission in the above regard, and we have found that the conclusions of the Commission are unsustainable. We thus hold that there is no case of extraordinary situation for exceeding the ceiling limit of 50% for grant of reservation to Marathas over and above 50% ceiling of reservation.
Yeah.
My lord may come to para 489 thereafterwards, where the amending act in Maharashtra was taken note of. My lord, as in contrast with the Madhya Pradesh Act, there were elaborate statements and objects of and reasons, my lord, for bringing about the amendment in the act. In Maratha, my lord, that is what has been reproduced in para 489. The statement of objects and reasons of the Maratha Act, of the Maharashtra Act. In 490, my lords, the Honorable Supreme Court says that the statements of objects of the bill clearly indicate that the state has formed the opinion on the basis of the report. Not there, the statements of objects and reasons themselves refer to the report. Here they do not refer to any report. What is simply said that the population is 27% and the state feels that they are backward socially, economically, and therefore In one line, the state has said, my lord, that they are required, although the state is taking up various measures, but they are not proving to be effective. And therefore, it is decided to enhance reservation from 14% to 27%. That's not the case in Maharashtra, and still it is struck down. The statement of objects of the bill clearly indicate that the state has formed the opinion on the basis of the report of the commissions and accepted the reason given by the commission, holding that extraordinary circumstances for exceeding the ceiling limit is made out. We have already in detail analyzed and noticed the report of the commission and have held that no extraordinary circumstances have been made out on the basis of reasoning given in the report. While the foundation itself is unsustainable, the formation of the opinion by the state to grant separate reservation to Marathas exceeding 50% limit is unsustainable. Then para 492 minutes. The Constitution Bench of this court in M. Nagaraj has reiterated the ceiling limit on reservation fixed at 50% is to preserve equality. In para 111 to 114, the following was laid down. The petitioner submitted that equality has been recognized to be a basic feature of our constitution. To preserve equality, a balance was struck in Indira Sani so as to ensure the basic structure of Articles 14, 15, and 16 remains intact. And at the same time, social upliftment as envisaged by the commission stood achieved. In order to balance and structure the equality, a ceiling limit on reservation was fixed at 50% of the cadre strength. Reservation was confined to initial recruitment and not extended to promotion. In Indira Sani, the equality which was protected by the rule of 50% was by balancing the rights of general category vis-a-vis the rights of OBC en bloc consisting OBC, SCs and STs. We have found that no extraordinary circumstances were made out in granting separate reservation to Maratha community by exceeding the 50% ceiling limit of reservation. The 2018 Act violates the principle of equality as enshrined in Article 16. The exceeding of ceiling limit without there being any exceptional circumstances clearly violates Article 14 and 16 of the Constitution, which makes the enactment ultra vires.
Yes.
So, my lord, regardless of the subsequent analysis which takes place with regard to the status of the Maratha community in Maharashtra, and that the Honorable Supreme Court says that the Marathas are a dominant class and have very good representation all over. Minus that, my lord, also the act has been held to be ultra vires, because the argument which might come from the other side is that this judgment was analyzing the status of Marathas and whether they are to be treated as OBCs and granted reservation in the state of Maharashtra. That part is separate, my lords. And this part, even without that part, is squarely applicable to the case at hand before my lords.
Yes.
My lord may skip over to, my lords, I will not read all that which is in para 499, 500, which talks about how the commission, the Gaikwad commission in that case, my lords, and there were other commissions also, which collected very elaborate data as compared to, my lord, almost no data at all in the report that we are dealing with in Mahajan case. My lord, this 499 and 500, my lord, may just take note of, my lord, that there was elaborate collection of data in those cases. My lord may skip over to para 513. The grant of, my lords, have para 513. My lords, the grant of reservation under Article 15.4 and 16.4, either when an executive order of a state or legislative measures are constitutional measures which are contemplated to fulfill the principle of equality. The measures taken under Articles 15.4 and 16.4 thus can be examined as to whether they violate any constitutional principle and are in conformity with the rights under Article 14, 15 and 16 of the Constitution. The scrutiny of measures taken by the state, either executive or legislative, thus has to pass the constitutional scrutiny. It is true that the court has to look into the report of the commission or committee with deference, but scrutiny to the extent as to whether constitutional principle has been violated or any constitutional requirements are not has not been taken into consideration is fully permissible, as laid down in V. Balram case. The judicial scrutiny is also permissible, so as to whether from the material collected by the commission or committee, The conclusions on which the commission has arrived is permissible and reasonable. Not one of the arguments which has come forth in the return is that the question of social backwardness is a subjective satisfaction of the state. So if the state is satisfied with the data, under Article 226 of the Constitution of India, we cannot challenge it. My lord, they would probably be citing Pavitra 1 and Pavitra 2 are the two judgments, my lord, of 2017 and 2019 of the Honorable Supreme Court, wherein the Honorable Supreme Court has made observations, my lord, that the collection of the data through a commission is an executive function of the state, and it is for the subjective satisfaction of the state to come to those aspects, my lord. But then Pavitra has been taken note of in these judgments also, my lords. Those are judgments, my lord, which are related to grant of promotion. And in matters of grant of promotion and consequential seniority in promotion, quantifiable data was collected. Pavitra 1 struck down the amendment to the act on the ground, my lord, that it violated the principles laid down in Nagaraj and no data was collected. So the state collected the data, and it arose from the state of Karnataka, and the state collected the data and made the amendment, my lord, and formed a new enactment. That was again subject matter of challenge in Pavitra 2, and the Honorable Supreme Court upheld it, saying that quantifiable data is there and we will not go into those aspects, my lord. But then those are not related to us, my lords. And in para 460, my lord, I'll just point out the specific paragraph where Pavitra 2 has been taken note of. I'll just point out the specific paragraph in this judgment itself. This is the subsequent judgment that your lordships are seeing. My lord, may skip over to para 542. This yesterday also, my lords, your lordships pointed out to the state, my lord. Indira Sahni has categorically held that what is required by the state for providing reservation under Article 16.4 is not proportionate reservation, but adequate representation. The commission thus proceeds to examine the entitlement under Article 16.4 of the concept of proportionate representation in the state services, which is a fundamental error committed by the commission. There can't be a concept of proportionate representation. Then, my lords, various aspects which do not concern us are there, my lord. I'll just skip over directly to the relevant portion where the Honorable Supreme Court finally draws the conclusions. Those would be, my lord, para 688 at page 323. These are the final conclusions of the judgment in Maratha reservation.
All these have been read over.
Conclusions have been read over?
Yes, yes.
So I will skip notes. Only one very important aspect is 688.13 minutes. My lord, because the commission's report was probably not read over to my lords earlier. The Constitution bench in M. Nagaraj does not contain any ratio or ceiling of 50%. Reservation may be exceeded by showing quantifiable contemporary data relating to backwardness. The commission has completely misread the ratio of the judgment when the commission took the view that on the quantifiable data, the ceiling of 50% can be breached. Only that I wanted to point out, my lord. All other aspects were there already. My lord, may just come back to the return for a moment, my lords, because the return relies upon a couple of judgments.
All right. So Nagaraj cannot be relied upon, but so far as breaching of the limit is concerned, that only the Indira Sahni is.
My lord, Nagaraj also says that 50% limit cannot be breached. And the
no, it is only the Indira Sahni who provides some guidelines.
Yes,
that is all.
Yes, Indira Sahni lays down the rule, lords. In fact, M.R. Balaji lays down the rule, which is affirmed in Indira Sahni.
Yes.
It was doubted in those Thomas's judgment and Akhil Bharatiya Pichla, my lord, which were my lords have considered yesterday, lords. Nagaraj, what was argued was Nagaraj permits the breach of the rule of 50% through quantifiable data, if quantifiable data is available. That has been set right in this.
Yes.
That there is no such law laid down in Nagaraj.
Yes.
So, my lord, may just come back to the return which has been filed. That the return also relies upon on the judgment of S.V. Joshi in para 11 notes. with regard to quantifiable data. My lord, since Pavitra would probably be cited from the other side, if my lords could just take note of that, Pavitra has been considered in para 500.
Why don't you leave their case to be argued by them?
True, my lords.
You will have a chance to
At the rejoinder.
respond to that.
My lord may therefore have just para 11 of the return for a moment.
Para 11
Of the return filed by the state.
in 5901.
My lords.
है कहाँ पे रिटर्न देख लो. Yes, return para.
Para 11 minutes. The part.
No, they have adopted the return in this
well-
of 16552.
My lord, my lord may have the return which has the main return in which para 11 is there. My lord, they are relying upon the judgment in the case of S.V. Joshi. S.V. Joshi, my lord, has been discussed in paragraphs 382, 383 and 384 of Maratha reservation. And it has been held, my lord, that the 50% rule cannot be violated or breached on the basis of quantifiable data.
They are relying upon
S.V. Joshi, my lord, 2012, volume 7 SCC. And that is dealt with in para 382, 383 and 384 of Maratha reservation. So the state, my lords, after hammering on
380.
382, 383 and 384.
All right. Yes.
And then referring to my lords Nagaraj and other, it has been held that there is no such law in S.V. Joshi which says that 50% rule can be breached on the basis of quantifiable data. It has been explained by the Supreme Court.
Yes.
I am not reading over, my lord, all those parts.
Yes.
Now, my lords, after going elaborately on the concept of proportionate representation justifying the enhancement of reservation on the basis of population, the only data which comes forth in the return is para 31, my lords. This is the only data that the state seeks to put forth.
31 of the return.
31 of the return. A bare perusal of, my lords have it at page 22.
Yes.
A bare perusal of annexure R7 leaves no iota of doubt with regard to educational backwardness.
What is R7? The report.
R7 is the is some data, my lord, that they have.
The report.
R3 is the report.
R3 is the report. Achha. Yes, yes.
R7 is the data, my lord, with regard to
yes.
registration. That's from the employment exchange.
Educational backwardness.
My lords. As well as other backwardness and backwardness of the other classes, other backward classes in the case of employment. The statistics goes to demonstrate that in case of other backward classes as against 109.6.65 thousands, only 0.62 placements are given to persons belonging to other backward classes. The other backward classes having a live register of 536.66 thousands. So this is the only data which is placed. With reference to employment exchange, with reference to public employments, appointments in public bodies through employment exchanges.
All right. Yes.
And there is nothing else so far as the social status is concerned. The social backwardness of the class. All that data is not there. Now, my lord, there is an effort probably by some of the petitioners to file an elaborate document of my lord, which was referred to as 3,500 pages through rejoinder, which is sought to be presented as the quantifiable data. My lord, I hadn't had the opportunity to go through it entirely. But the attempt probably is to show that there is quantifiable data available. This can't be brought in support of the impugned legislation because the impugned legislation is not based on this data. So, my lord, any data which is now collected to support the legislation is totally irrelevant at this stage. The legislation has to
No, brought by whom? The interveners.
no, some petitioner lords who are supporting the legislation. They have themselves collected that data, my lord, from probably, my lord, from what sources. I haven't had the opportunity to, copy has not been given to me, my lord, but that is what I am given to understand. But then that's not in consideration before the legislature when the impugned enactment was framed.
Yes.
So therefore, my lord, I just sum up the submission, my lord, that the data, there is no data in the first place. The commission's report is prior to Indira Sahni 83. It relies upon various judgments which have already been declared to be no more holding the field in Indira Sahni.
Yes.
And the commission seeks to bring in proportionate representation, which is struck down, bro, by the Honorable Supreme Court in Indira Sahni and all subsequent judgments.
Yes.
And that is what the stand of the state is, my lord. Therefore, my respectful submission is that the impugned amendment is completely ultra vires, deserves to be struck down.
All right.
So much obliged.